Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hardworking Americans and their families? You will. This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefit in benefit plan. Now prepare to learn, plan, save, and protect with the Phia Group.
Hello, and welcome to the newest episode of the Phia Group's podcast, Empowering Plans. I am John Jablon, and attorney Katie MacLeod is on the line as well. Say hello, Katie.
Hi, John.
Hi. I'm always expecting people to do the Ron thing, where Adam says, say hello, Ron, and he says, hello, Ron, and it's just so dorky. But I'm glad that you did it right and actually said hello to me instead of to yourself. But anyway, today, Katie and I are here to talk about an issue that is just constantly relevant to the self-funded industry and TPAs in particular, and that is fiduciary duties. If you are a longtime listener of the Phia Group's podcasts and webinars and myriad other content, you've heard us talk and write about fiduciary duties so many times. And the reason for that is because they're always relevant and there's always new stuff going on. And now is definitely no exception with the No Surprises Act and mental health parity and all this fun stuff popping up and just getting more and more relevant. Fiduciary duties are as pervasive as ever, if not more important, frankly. So we want to talk about some issues that are a bit different than what we're normally used to. And that, of course, keeps things interesting for us at the Phia Group and in the industry. And interesting is not always a great thing. And we'll show you a little bit of that here today. But in order to talk about what's different from usual, I'm going to go through for a bit just what is usual. And if any of this catches you off guard, send us an email because that's not ideal. We want to make sure that everybody knows what they're supposed to do and frankly what they're not supposed to do. So if any of this, any of what I'm about to say, you hear it and you say, oh, I didn't know that, I've been doing it all wrong, let us know. We're happy to help. Traditionally, the basic fiduciary duties that all health plan related fiduciaries have, there are a number of them that are iterated in different ways by different courts, but the basic ones, you have to act solely in the interest of plan participants with the exclusive purpose of providing benefits. That much is somewhat intuitive, I think. You have to hold plan assets in trust. There are a number of questions about what exactly that means, and if you've got any, we can certainly help. You've got to follow the plan documents that are in effect. That one also seems somewhat intuitive. And then you have to act prudently under the circumstances. That is probably the most complicated one, mainly because what exactly acting prudently means, it can differ on a case-by-case basis. What might be prudent in one circumstance might not be the most prudent way to proceed in another circumstance. So that one, there's the absolute rule of, well, be prudent. But then, of course, there are just so many questions of, well, is this prudent? Who knows? It's a really good question. Sometimes it's very obvious that, no, that's not prudent. But other times it's a bit of a gray area. So it can get really complicated. And as most of you TPAs out there know, in general, not always, but in general, if all you're doing is ministerial function, so if you're not making any coverage determinations, right? If the plan is saying, hey, pay this amount, and you say, okay, we will pay this amount. If you're doing that, you are not a fiduciary with respect to just doing that because you're just sort of following orders. You're just doing exactly what the governing documents and what your client tells you to do. You're not exercising discretion. You're not making any decisions. You're just basically doing what you're told. And that is certainly not meant to belittle TPAs. Obviously, TPAs are absolutely crucial to the self-funded process, but it just so happens that TPAs serve different roles. Some of them take on a more active role, and there's usually more money involved in those transactions, but some of the TPAs want a more passive role because you're good at what you do and you want to just kind of get the plan's operations done in the way the plan wants it. Both are completely fine and totally legitimate. There are just different types of fiduciary concerns depending on what exactly you're doing. So generally, an example of a purely ministerial duty would be to deny cosmetic services when the SPD is very specific that it does not cover cosmetic services. In that example, if a claim comes in, you don't need to make any decisions. You don't need to exercise any discretion. The SPD says X, you do X. It kind of couldn't be simpler. Now, an example of when it's not ministerial, when you might become a fiduciary, is if you make a discretionary interpretation for something like a hazardous activities exclusion. So if the exclusion says something like, hazardous activities are not covered by this plan, and they include bungee jumping and ATV riding and other things of the sort. Well, a claim comes in for, say, water skiing. Somebody got hurt while water skiing. If the TPA says, yeah, you know what? We think that that falls in that same vein, we're going to exclude this. There's nothing explicitly wrong with that, but the TPA has, in that case, become a fiduciary because you've interpreted the plan's language to decide what the plan actually means. So just some examples, right? Some TPAs really want to be fiduciaries. They say, you know what? We want to charge for this. We want to make some extra money. We've got the know-how. We've got the expertise. We've got a few clinicians on staff. We've got access to lawyers. Fantastic. We can do this. We're not worried about it. We've got the expertise. We know what we're doing. We might as well capitalize it. And frankly, a lot of groups, maybe even most groups, expect their TPAs to do stuff like that. I can't tell you how many times I've personally heard a group, or mostly I see it in writing, but I've seen a group say to a TPA, wait a minute, isn't that what we pay you for to make these decisions? And as a TPA, you can give one of a couple of answers. One answer is, yeah, we got it, don't worry. And another answer is, well, no, you pay us to, kind of do what you tell us. But when it comes to exercising discretion, that's not our job. That is your job. You need to do it as the fiduciary. There are a number of ways to handle it. And as a TPA, you can kind of choose whichever you want. But please remember that whatever you decide to do, the Phia Group is here to help. We offer just so much consulting guidance on a daily basis. Trust us when we say we've seen it before. Your issue is probably not novel to us. I'm sure that we can find a way to help you. And frankly, even if it is novel to us, we love novel issues. Please give us a fun, complicated fact pattern, and somebody like myself or Brady Bizarro, we love sinking our teeth into it. And the last thing I want to say about kind of how things are normally done before Katie's going to start talking about some changes in that, don't forget, fiduciary responsibility, it's not inherently bad. There's nothing just automatically terrible about being a fiduciary. Sure, you owe a higher duty, a higher standard of care, but it's only a problem if you screw stuff up. And that might sound a little bit crass, but it's true. For the example I gave of the TPA, that they've got the know-how, they've got the resources, they know what they're doing, they're okay being a fiduciary, it's not a terrible thing. If they're right and they can do this correctly, there's nothing inherently wrong with being a fiduciary. A lot of people hear that word and they say, oh, no, we can't be a fiduciary. Well, why not? Maybe you can be a fiduciary and you're just not giving yourselves enough credit. Just some food for thought. So, Katie, let's talk about mental health parity. Your favorite topic, huh?
Yeah, definitely my favorite topic. And generally, how the MHPAA links in with this topic of fiduciary duties, there's been a lot of recent litigation against TPAs or vendors with a plan. Traditionally, most mental health parity lawsuits have been filed against plans, but there has been a recent trend on filing suits against TPAs, network vendors, entities like that. The number one case on people's minds that's been published in the last year has been Doe versus United Behavioral Health. Basically, this plan had a non-compliant exclusion for ABA therapy and IBT therapy. United enforced this exclusion exactly as written, literally just following the directions of the plan document as written, but the court in this case indicated that because United acted based off of the plan document as written and did not consider compliance with other federal laws such as ERISA, United chose in this instance to exercise some discretion when adjudicating its claims because the plan UBH did violate the fiduciary duty when it acted in a manner inconsistent with ERISA while following what was written in the plan document.
Just to pause there, I think it's really important to note that even though UBH basically did what the plan said, what you said there, it's really interesting. Acting in a manner inconsistent with ERISA, that is actually an important part of the fiduciary duties that I didn't note above because I wanted it to kind of be a wow factor. It's you have to act prudently, you have to follow the plan documents, but you have to follow the plan documents to the extent they're not inconsistent with ERISA. And that's actually something that's really tough to know in a lot of cases, right? Because when you're looking at a plan doc and it says to do X and you say, all right, I'm going to do X. Sounds great. Easy, right? The plan document just says it. I'm going to do it. Well, if there's some facet of ERISA, right? Maybe it's some, random case law that's buried that no one's dug up in 20 years. Who knows? If it is ultimately found to be inconsistent with ERISA, that can become a fiduciary problem. So I think that that's one of the really interesting parts of this case that we sort of don't see super often. We see a lot of stuff, but interpreting a plan document in a manner inconsistent with ERISA tends to be one of the, I don't want to say rare, but it's probably more rare than the other fiduciary violations. So sorry for interrupting, but take it away.
No worries. I think you're right, exactly what you said. I think it is kind of novel to some individuals that, having the authority to, review, grant, deny any claims under a plan can be sufficient to confer fiduciary status under ERISA, exactly in this type of case where they are having to consider other factors beyond what's written in the plan. So another case that's been out and about, that people have been asking us about, is this Blue Cross Blue Shield of Illinois class action. Basically, a TPA administered a gender affirmation treatment exclusion. They administered claims completely in line with what was drafted in the plan document, but just like United Behavioral Health, the court in this case found that the following orders by following what's written in the plan was not enough to preclude these individuals from being considered a fiduciary in this case, because gender affirmation treatment, as you may know, can be considered a mental health benefit, but also can be considered protected under certain statutes like 1557.
Yeah, and on that topic, 1557 is actually a really hot topic right now, as many of you listening to this may know or may have faced issues yourselves. But, in fact, a recent example, and this is not quite litigation, but it's still very relevant here. One of our client TPAs recently fielded a complaint from GLAD, G-L-A-D. Basically, the argument was, well, you, as the TPA, administered a gender dysphoria exclusion for one particular plan. And this plan happens to not actually be subject to Section 1557. So this plan's exclusion did not violate the law. But the complaint from GLAD basically said, look, what you're doing is illegal. 1557 is very specific, and there's state law that prohibits discrimination like this. And one of the allegations was the TPA was aiding and abetting state law discrimination, which is an interesting take. But basically, the letter from GLAD requested that the TPA itself rectify the situation monetarily. And it also requested that the TPA refuse to administer such an exclusion in the future for any of its benefit plans. Obviously, gender dysphoria is an incredibly sensitive and complex topic, and a lot of plans are really struggling with how to navigate those waters. But there are external forces in play, like, for instance, 1557 and state law are not the only things that might apply. The Americans with Disabilities Act, for instance, could even be relevant to something like this. I mean, we're talking mental health parity, ADA, state law, 1557. Any number of laws might become relevant at any given time. And, a good argument, who knows what'll happen, right? I mean, court is like the Wild West, is what we often tell people. It doesn't matter how much of a slam dunk you think your argument against being a fiduciary or violating fiduciaries may be. Once it's in court, anything can happen, and it's kind of a scary prospect. But obviously, this is one of the aspects of law that is a bit less well settled than others. Some have been well settled for decades now, since ERISA was passed in 1974. Whereas this type of thing in 1557, it's still relatively recent. That's a very interesting aspect of this whole kind of fiduciary, well, call it a game. So what we were talking about there is mostly TPAs. There's also a trend in vendor litigation. And, in the list of vendor litigation, we've again got United Behavioral Health on the list, this time together with Multiplan. The two together are alleged to have systematically repriced claims whereby reducing payment specific to mental health and substance abuse disorder claims. Obviously, that presents a mental health parity problem. Whether or not it is, actually the case that they did this or not, it's too early in this litigation to know, but that's the allegation. Anyway, and the argument that Multiplan put out is that, well, look, UBH and Multiplan, they're just vendors, right? They didn't have the authority to make decisions. All they were doing was repricing claims at preset rates. Basically, plan or TPA sends them a claim, they reprice it, they send you back a number. How the heck are they fiduciaries? And, even if they were, how the heck are they violating their fiduciary duties? But the crux here, the interesting thing, case law is very clear that when a vendor, even a TPA, right, a repricer or TPA, it doesn't matter who, when someone uses its own policies rather than the plan documents, the vendor is acting as a fiduciary by effectively changing the plan and deciding to do things other than the plan. So it's really interesting because, no matter what the plan says, if the vendor does something different, whether that vendor is a TPA, a repricer, just anybody, right? That entity who's doing something different from the plan and basically using discretion to do that is a fiduciary and may well be violating fiduciary duties. So that's interesting stuff. And of course, there's a huge effect on mental health parity compliance. That federal law is not quite at the level of allowing investigation or sanctions against vendors. They're not quite there. Sorry, Katie, who was it that made the report to Congress? Was it the Department of Labor specifically?
It was EBSA and CMS combined.
Right. Yeah. So they basically said that, look, there are lots of vendors that we know are not giving information, but at this point, we're not going to do anything about it. What they want instead is when plans complete their NQTL analyses, they want plans to identify the vendors by names and say, basically, look, this vendor, we asked them for our plan data. They won't give it to us. They will not allow us to actually analyze our own plans. So the Department of Labor has not actually done anything to enforce anything against vendors, but they're potentially looking into it, whatever that means, right? I mean, maybe 10 years from now they'll do something, or more likely not. But the bottom line is that all plans can do right now is hope like heck that their vendors allow them to be compliant and allow them to prove compliance. And it's an interesting issue. And Katie, I'm hoping that you can tell the listeners about some of the stuff that you've seen in the NQTL world about, when plans request data from vendors. I mean, what's some of the stuff you're seeing?
It really depends. I think a lot of vendors are trying to comply with the law, but there are a lot of even larger vendors that have taken the stance the DOL hasn't released specific guidance on what is actually required for the analysis, so they're just not going to send anything. Or if they are sending stuff, they're only sending things that's relevant to their fully insured book of business rather than their self-insured book of business, which is really, a problem. A lot of times vendors can send things on a book of business level, but in order to comply with the Mental Health Parity Addiction Equity Act, you need to prove that your plan is operating in parity and operation at the plan level, not on a book of business level. There has been, I think, a lot more vendors who are kind of getting with the program now that the CAA has been in effect for almost 2 years now, but there's a lot of struggles with vendors in the industry just not complying, not trying to comply, and only really helping out their plans when there is a DOL audit in effect.
Crazy stuff, Katie. So what now? Where are we going? What does it look like? Katie, what does it look like?
Well, courts seem to be cracking down on a lot of different vendors, as we've talked about today with the UBH and BCBS cases. And vendors really need to be able to consider that they might not just be able to hide behind this just following orders, following the plan document as written defense. They need to know that there's a risk that any action that they could make them a fiduciary if they do have any discretion or if they do act in a fiduciary manner in even just one transaction. Definitely something to keep in mind. Obviously, there's potential for new regulations regarding, mental health parity or other things like the Mental Health Matters Act, where vendors could be on the hook even if they're not considered fiduciaries for the plan. But of course, it hasn't passed Congress yet. But I think it's very important for vendors to be aware of the risks inherent in their actions, as well as whether they're willing to take on the fiduciary duties for the plans.
Yeah, that's interesting. I mean, primarily the laws we're talking about, like mental health parity and even just kind of general law about fiduciaries, it's important to remember that at their cores, these are consumer protection laws, right? And even something like the No Surprises Act, I mean, it's all designed to protect consumers. So I guess, frankly, everybody, right? Health plans, TPAs, all sorts of vendors, consultants, everybody. You need to make sure that your processes are fully aligned with exactly what's expected of you and make sure that what you're doing aligns with the plan document. And, frankly, that's the reason that so many vendors give plans language to put in to affect their programs. And, whenever we see a vendor who says, oh, no, we don't need any special plan language, we operate within your existing framework, it's possible that that is absolutely accurate, but I can't tell you how many times we've seen a program, we've looked at it and said, well, no, oh boy, you should have language. How are you doing this without language? That's insane. So just, be wary, be careful, and make sure that everything you're doing is above board. And if you've got questions on whether it is or how to make it so, contact the Phia Group. We are here to help. We know the ins and outs of fiduciary duties. I mean, a shameless plug for our services, but at the same time, it's extremely relevant to how TPAs, brokers, vendors, to how the industry does business. We're able to help with whatever you need. Please don't forget that. So with that, I think we'll let you go. On behalf of myself, John Jablon, Katie MacLeod, and the whole Phia team, thank you so much for listening, and we'll talk to you soon. Take care.